An action for patent revocation can be brought in the UPC regardless of whether an infringement action between the same parties concerning the same patent or patents has already been filed. This means it is possible for any person or a company to challenge the validity of European patents and unitary patents in the UPC in order to remove them from the EPO register. It is also irrelevant whether oppositions and appeal proceedings have been started in the EPO relating to the same patents, except in those relatively few cases where a rapid decision may be expected from the EPO. In these cases, the UPC may stay its proceedings to wait for the EPO decision. The possible grounds for revocation are the same as those that would be applied in national and EPO proceedings, such as lack of novelty, obviousness, and insufficiency. A successful revocation of the patent has retroactive effect, meaning the patent is regarded as having not been granted from the outset. Revocation is also possible in part. The basic rule on where to bring a revocation action is that the branch of the central division relevant to the subject matter of the patent has jurisdiction for actions for revocation. The central division is divided between branches in Paris, Munich, and Milan. Electronics, mechanical inventions, and pharmaceutical and biotech inventions will be allocated between these three branches. If the third party revoking the patent is alleged to engage in or threaten to engage in infringing activity of the patent before the conclusion of revocation proceedings, the patent holder or their licensee may bring an infringement claim or infringement counterclaim against that party. If this happens, the patent holder or licensee may be able to choose one of the local divisions of the court to file that action. The local court will need to decide whether to join the revocation action and infringement actions in the central division or allow them to remain separate, that is, bifurcated. There is currently no guidance on the factors a panel will consider when making a decision either way in this situation. It is expected that the earlier the revocation action is started before any alleged infringing activity, the less likely the actions are to be joined, and the more likely the revocation action is to be decided first. This could mean the patent is revoked before an infringement decision can be made, which is an important strategic advantage.